record in the matter of the state of Michigan versus Dane Austin. Excuse me, 26-00232. Please.
Anna Buckingham for the people requesting to practice under 8.120 under the supervision of APA Bart Buxton.
Permission granted.
Jacob Riley on behalf of Mr. Austin, who is appearing remotely from Bingham County Jail.
Okay, this was a trial conference that was scheduled for 2 counts of police officer assault and breaking and entering. I see that there's an offer for the defendant to plead guilty to count 1 of an amended attempted RNO, and that the people will dismiss count 2. And the defendant is to plead to count 3.
Correct, Your Honor. With an agreement. An agreement, no upfront jail.
A chemical agreement to no upfront jail. That's accurate.
Yes, Your Honor.
And Mr. Austin, that's your understanding of the plea offer?
I really couldn't hear anything. It's hard to hear. It's all right.
Okay. There's an offer for you to plead guilty to attempted resisting, obstructing an officer and to the breaking and entering. Can you hear that?
Yes.
You want to accept that offer?
Yes.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes.
You can put your hand down. Mr. Austin, you have the right to the presumption that you're innocent, and you're innocent until proven guilty. You have the right to maintain that presumption of innocence and take this matter to jury trial and require the prosecutor prove each element of the charges being brought against you beyond a reasonable doubt. You understand that?
Yes, I do.
You have the right to see, hear, or question any witness called to testify against you, the right to subpoena witnesses to testify on your behalf, the right to remain silent at trial and not have silence be used against you, or you can waive silence and take the stand at your own trial. Do you understand that?
Yes, I do.
And are you willing to give up all of those rights to plead guilty today?
Yes.
Okay, is anyone threatening you to get you to waive those rights and enter a guilty plea?
Yes.
Who's threatening you?
Nobody.
My question was, is anyone threatening you to get you to plead guilty? You said yes.
Yes.
Who's threatening you?
No. Nobody's threatening me. Nobody.
My question was, is anyone threatening you to get you to plead guilty? You keep saying yes.
Oh, I'm sorry. No, nobody's threatening me. I'm sorry.
Okay. Any promises to get you to waive your rights and plead guilty?
No promises. No.
Are you on probation or on parole?
Yes.
You're on parole until when?
To the end of this year.
You understand that by pleading guilty, this could have impact on your parole status, correct?
Yes.
It also could have impact on where you can travel or get immigration status. You understand that?
Yes.
You also may need to report this conviction on a future job application. You're clear on that as well?
Yes.
Okay. As to the amended count 1 of attempting, resisting, obstructing an officer, how do you plead?
Guilty.
And as to count 3 of breaking and entering vehicle to steal property less than $200, how do you plead?
Guilty.
Is that because you believe you're guilty?
Yes.
Factual basis?
Your Honor. Mr. Austin, on January 24th this year, 2026, right, is it true that you were at the location at or near 1123 West Washtenaw Street in Lansing?
Yes.
That's in the city of Lansing, Ingham County, state of Michigan, correct?
Yes.
And at or near that location, is it true that you opened a vehicle that did not belong to you and you did not have permission of its owner?
Yes.
What is the problem, sir?
There's there's no problem, ma'am.
No, there is a problem. You seem distressed.
I'm accepting the plea. I'm just gonna accept the guilty plea now. Yes, I did. Yes.
I'm not accepting the plea. Set this for in person, please. Well, actually, this is scheduled for exam next week.
That's right.
Please
It's
reject
my
it.
medication. It's my medication, ma'am. It's my
Well,
medication.
then I definitely can't accept the plea. If you're under the influence of something, then
No, I'm not under the influence.
do not talk over me. Do not talk over me. I have already made my ruling. You don't get to go back and forth with me about my ruling. Do you understand that? I am not accepting your plea has been rejected by me. We'll see you in person next week, February 12th at 8:30. I don't accept pleas under distress. Any additional matters for the record?
Can I speak, ma'am?
We'll
You
talk
need to
later.
talk to your attorney, sir. Okay? We'll
Yes,
talk
ma'am.
to you in person next week.
Nothing from the people.
Not the pretty.
You're all set.
I just can't accept nothing I can't do. I didn't do it. I just didn't do it.
That's why I didn't accept the plea. You're all set, sir.
So I didn't accept something I didn't do. I just can't accept the plea. I really accept it.
State of Michigan versus Giannina Ballerini, 25-00893, 25-00220, appearances, please.
Anna Buckingham for the people. Assistant Public Defender Mr. Straw on behalf of Ms. Ballerini, who is preparing for remote.
You're in the jail when we're done with this. Whoever we're done with in the jail. Okay, today was the date that was scheduled for a competency review. I do have an updated report. This is from the Kalamazoo Psychiatric Hospital. I think we received this report on the 2nd of February. Did council get a copy of this?
Yes, Your Honor.
Okay. The report finds that at this time, the defendant still remains incompetent to stand trial, but it is the belief that she could be restored within a 90-day period, I suppose. Is there any reason to object to the report?
Your Honor, the people stipulate to the report. None from the defense.
The court will adopt the report, will incorporate it into the court record on each file. And she'll be ordered to undergo treatment to see if she can regain competency. And we'll wait for a status update from the forensic center. Any additional matters for the record today?
Not from the people. Nothing further, Your Honor. Thank you.
Thank you, you're all set. Ms. Ballerini is all set for today. State of Michigan versus David Brown, 26-00261, appearance, please.
Anna Buckingham for the people.
Mr. Brown is on my Zoom. Mr. Brown, can you hear me?
Yes, ma'am.
You can remove your hat and your hood. Okay. Today was the date that was scheduled for a probable cause conference. My understanding is that Mr. Brown was denied a public defender. Is that accurate?
Yes.
Okay, Mr. Brown, are you seeking to hire an attorney now?
Yes, ma'am.
Have you made contact with any attorneys?
Yeah, I'm currently meeting with a few. They just trying to break down my financial situations.
You're meeting with whom?
What's that, ma'am?
You say you're currently meeting with whom?
I said I'm currently meeting with a few attorneys now, and we're just kind of.
What's their local attorneys?
Yes. What's his name? Eric Shepard.
Okay, so you haven't identified which one you may likely go with yet.
No, ma'am.
Okay, you do have an exam scheduled next week, February 12th at 8:30 in the morning. I'm going to continue that date. You need to appear and advise us of an update about your attorney, okay?
Yes, ma'am.
I'll treat next week as another probable cause conference.
The people do have an offer if you would like that on the record.
What is the offer?
The offer is 1 count of felonious assault and 1 count of CCW dismissal of balance.
1 count felonious assault and what?
1 count of concealed weapon.
Okay, I'll note that in the file. He'll get counsel and then he'll have an opportunity to consider that offer. Do you have any questions today, Mr. Brown?
No, ma'am.
Okay, any additional matters for the record?
Not from the people.
Okay, we'll see you next week, sir.
All right, thank you.
You're welcome.
How do I do this?
State of Michigan versus Jawan Edwards, 25-03044, appearance case.
Anna Buckingham for the people.
Likely on behalf of Mr. Edwards.
Okay, today was the date that was set for probable cause conference. He did indicate at his last court date in January that he was seeking to obtain Mr. Blackman. Mr. Blackman, are we continuing, that is, to an exam on this?
Judge, at this point, my client's gonna waive this 21-day rule. We have days
It's been
already.
He waived it in January.
Oh, did he, Judge? Okay, thank you. I haven't got the discovery yet, Judge, and the PCC now is 219. And the preliminary exam is 3/6. Third that date. Yeah.
You still don't have discovery. You filed an appearance?
Yes. It's just been real recent. The last few days.
Okay. What is the date?
February 19th for the PCC at 9 a.m. And then the exam is March 6th at 9 a.m.
Anything we need to address on the record?
Nothing more.
Okay, we'll see you on February 19th. Thank you. This is on here, is that the issue? Okay, that's the state of Michigan versus Keandre Morgan, 25-03811. And then I have a state of Michigan versus John Velasquez and Hicks, 25-03769.
Your Honor, I'll need to grab Randy Fairman. Honor, actually, Mr. Berman is on the record in Judge Flores' courtroom right now.
Off the record on that one. Record in the matter of the state of Michigan versus Brandon Jackson, 25-03770. Appears.
That is also Mr. Berman.
Oh, okay.
Last one of his.
Sorry, Mr. Black. State of Michigan versus Jeffrey McKenzie, 25-02814. I need a prosecutor for that one.
Anna Buckingham for the people. On behalf of Mr. McKenzie today, sitting in for court-appointed counsel Luke Goodrich.
Why don't I have a PSI?
Sorry.
Why do I not have a pre-sentence report?
It appears that my client got the dates mixed up for that.
Did it? And so he appeared later?
He did not.
He did not? So you didn't get the dates mixed up? You didn't follow the court order? He'll be remanded so I can get a PSI. It's pretty simple. It was pretty simple order. Meet with probation. Okay, Mr. Chairman is here. On the record of the matter of the state of Michigan versus DeAndre Morgan versus John Velasquez Hicks. I'm sorry. Let me clear my brain. On the record of the matter of the state of Michigan versus DeAndre Morgan and the state of Michigan versus John Velasquez Hicks. Appearances, please.
Thank you, Your Honor. Randall Berman on behalf of the people.
Fred Black on behalf of Mr. Berman.
May it please this honorable court, Michael Nichols on behalf of John Velasquez Hicks. I'm appearing by Zoom. I can hear you and see you.
Thank you. Let's see. Okay, so it looks like Mr. Velasquez Hicks was wedded to Eaton County.
That's correct, Your Honor. I think I mentioned this last week. He's being sentenced today to a 6-month term for another case unrelated to this case. So he will be in jail for 6 months, less 22 days credit from the day of his arraignment on this case. The court found good cause, I think, 2 PCs ago to waive the 21-day requirement.
Okay, I think my note is just what was inaccurate. I had that he would be in ICJ for approximately 6 months, but he's going to be in Eaton County for 6 months.
We'll find out today if Judge Morton will have him sent back to Ingham County or if he'll serve his time in Eaton County. It's a difference
Okay.
between an E or an I, ECJ or I.
Agreed.
Yeah.
Well, that just, we just need to know how we read it. That's the issue.
Yeah.
So, okay, well, thank you for that update. It looks like we did waive his timeline, partially, I think, due to case consolidation. We now have Mr. Morgan here. This is his first appearance. This is for probable cause conference, and he's scheduled for an exam on the 12th of February. Are we continuing to examine?
Judge, we've got discovery. It's voluminous.
That's a lot of discovery.
A lot of discovery, and I talked with Mr. Berman, all right, in regards to that, talked to my client. I've gone over his 21-day rule. We likewise would ask the court waive this 21-day rule today and set dates.
Ma'am, ma'am, I need you to step outside because it's interfering with the record.
Just tell you.
Thank you. Mr. Blackman?
Again?
Yes, because I don't think she could pick it up on the record.
Okay, Judge, I started out by indicating that we've got discovery, it's voluminous. I talked with my client, you guys use 21-day rule, I believe he understands it, and based upon that reason and just getting on the case, Judge, I'd ask the court to adjourn the preliminary exam dates and reset them that are convenient with myself and also co-counsel.
Okay, how much time do you think you need for review of discovery?
There's a lot.
There's a lot. I would agree with Mike about that, Judge. I wait 60 days.
And that's not a problem for me because Mr. Velasquez 6 will be in custody anyway.
Okay, and obviously there's no objection to that.
I have no objection. I think the defense obviously needs to be prepared, so people would agree with whatever is requested. So
Okay, I understand that you advise your client of the right to waive the 21 days. You understand you have the right to have your exam within 21 days of your arraignment date, correct? Okay, and due to the magnitude of discovery, that's the evidence that's been compounded and provided to your attorney. Are you willing to waive that timeline to give him ample time to go through that and to have time to counsel you with that evidence? Okay. And no one's threatening you to get you to waive that timeline?
No.
Okay, we are going to adjourn both 60 days.
Now, just to make sure, when they said it, I have, at the end of March, I have a conference down in Myrtle Beach.
Well, that's not 60 days yet.
Pardon me?
March wouldn't be 60 days.
I know, but
Definitely
then also the end, 3-4 days, at the end of April, another.
He's just really busy, huh, Mr. Black?
Well, these conferences out of state. I'm sorry, I'm gonna be truthful. I'm playing golf.
Okay. Last week of April is not good for you?
No, last week is.
And
First
last week
week.
of March. Any other conflicts? Anybody got trials coming up?
I'm not as busy as Mr. Blackman, but first week of April is bad for me. It's our family spring break ski trip, April 2nd through that first week of April.
Okay,
I'm just here working, Judge.
just public servant. Thank you.
That's correct.
Okay.
How long do they think the exam is gonna be?
How much time do we need for the exam? Do we need to block a full day?
Probably. Judge.
Probably.
Yeah.
Do April 16th at 9:30.
April 16th at 9:30?
That's good by me, Judge.
Okay.
Thank you, Your Honor.
Yes.
Okay, that's the date, April 16th, 9:30 in person at the court.
Thank you, Your Honor.
No problem. Any additional matters for the record?
Nothing on behalf of the people, Your Honor. Thank you.
Nothing on behalf of us.
Thank you.
Thank you.
Thank you.
I pulled it forward.
Okay. George. Arhim. State of Michigan versus George Arhim. 6-00035. Appearance, please.
Him for the people.
Jacob Riley on behalf of Mr. Arhim, who appears remotely from Dane County Jail.
Is that Mr. Arhim stretching?
It is.
Yeah.
Okay. Today was the date scheduled for a probable cause conference. This is for carrying a concealed weapon. There is an exam scheduled on the 12th of February at 9 AM in person at the court. Are we running an exam or expecting to?
Your Honor, there is no offer at this time, but people would be prepared to proceed preliminary exam.
Yes, Your Honor.
Okay, so we'll see Mr. Arhim in court, in person next week. On Thursday, he's gonna get a good night's rest the day before, so he doesn't have to sleep through court. Okay?
Yes, Your Honor.
Okay, do you have any questions at this time?
No.
Okay, any additional matters for the record?
Not really people.
Your Honor.
Okay, we'll see you next week, sir.
Take care.
Thank you. State of Michigan versus Smith Jackson, 25-03770. Appearance, please.
Good morning, Your Honor. Randall Berman on behalf of the people.
Fred Blackman on behalf of Mr. Jackson, and he's approaching.
Okay, Mr. Jackson is scheduled today for a probable cause conference. This is operating while under the influence causing death and a reckless driving death. How are we proceeding?
I might, I've talked to Mr. Newman, I've just gotten discovery, and I'm gonna use the same term, voluminous discovery on this case also, Jim. And I talked to the client on the 21-day rule. I didn't understand it the way that I would be asking for a date. Whenever the courts, will probably, I don't, probably right around 60 days again. I mean, I spend the whole week with you on both of those.
Well, that's exciting.
I didn't know, that's fine.
No objection, obviously. I
No
gotta get-
objection. I just, obviously, I don't think the same day would be.
Yeah.
Well, we just blocked that day for it, so it can't be that day. Sir, you understand your right to have your exam within 21 days?
Yes, Your Honor.
And you're willing to waive that so your attorney has time to go through discovery with you?
Yes, Your Honor.
Okay. You said April
17th and 9:30.
April 17th at 9:30.
That's good.
Fine, Your Honor. Thank you.
It's gonna wear me out in 1 week. Right?
Thank you, Anna.
Okay, that's set for PE. Any additional matters for the record?
Not on behalf of the people, Your Honor. Thank you.
Nothing on behalf of the point seven, but
Okay, that's that one.
Just pick it up.
thank you.
Okay, Kaplan is here on green. Is green downstairs?
Yes,
Are we running an exam?
yeah.
Can you brought up?
Before you start the exam, Your Honor, I believe Brandon Orr is going to be a plea. I mean, if you want to handle that before. At 10 o'clock.
Oh, okay, State of Michigan versus Brandon or Price, 25-03516.
Good morning, Your Honor. APA Bartley Buxton on behalf.
Anna Buckingham on behalf of the people. And Assistant Public Defender Sarah Donnelly on behalf of the defendant Brandon Orr Price, who is standing to my right.
Okay, I see here that there's been an offer extended for Mr. Orr Price to plead guilty to amended count 1 of attempted RNL, count 2 assault and battery as charged. Oh, it's gonna be a no contest plea due to intoxication.
Yes, Your Honor.
That's what you want to do?
Yes.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes.
You can put your hand down. Are you having advice and rights and plea information sheet that has a signature twice? Already have page 2. This is the older version, so that's why the thing is on that. So if you get an older version, you don't need this page. Because it's the same, it's just number 12 on this one. So your signature is on this.
Yes.
You've gone over these rights.
Yes.
Do you have any questions about these rights?
No.
You understand that you have to give up all of these rights today if you want to plead guilty to the amended count 1 and to the count 2?
Yes.
Okay, so that means that you are presumed innocent right now until proven guilty. You would give that right up?
Yeah.
You have the right to proceed to trial and have the prosecutor prove your guilt by proving each element of the charge beyond a reasonable doubt. You have the right to see, hear, or question any witness called to testify against you, the right to subpoena witnesses to testify on your behalf. You understand that?
Yes.
Anyone threatening you or coercing you to waive your rights today?
No.
Okay, and you want to enter a no contest plea freely and voluntarily?
Yes, that's correct.
Are you currently on probation or on parole?
No.
You understand that if a conviction is sustained by way of your no contest plea, it could result in a conviction that you may need to report to your employer, or you might need to put it on a future job application.
Yes.
It also could have impact on where you can travel or get immigration status. You understand that?
Yes.
As to count 1 or amended count 1 of attempted police officer assault, resist, obstruct, how do you plead?
No contest.
And then as to assault and battery, how do you plead?
No contest.
We got a police report from the Manson Police Department here. Incident report 25-06-698-1. On or about November 21st, 2025, approximately 2:19 at 3612 Malibu Drive, Lansing, Michigan. Officers made a report that Tavaos Cooper Ross advised he was over the house visiting his mother, Marcel Cooper. Cooper Ross went outside and observed the accused grabbing his mom by the hair, falling over, then grabbing her by the ankle. Officers spoke with Marcel Cooper on the scene, who advised that she had been in a physical altercation with the person identified as Brandon, and that altercation was broken up by her son, Tavius. Officers also there's more than one officer report here. Let's see. It says officers approached the target address 3612 Malibu Drive from the east and observed a subject matching the dispatch description. Officers exited the patrol vehicle, approached the person identified as Brandon. I think the description is a black male, approximately 30 to 40 years old, with a short afro, wearing a white t-shirt in jeans. Officers were able to positively identify the subject by Michigan ID. Let's see. The person identified as Brandon, arms were up and out to the side, allowing the officers to grab both forearms before placing them behind his back in handcuffing positions. And then it was handcuffed. Brandon sat up on the sidewalk, becoming belligerent, shown by yelling at his family members and officers on the scene. It says officers once again, I guess, requested or asked Mr. Brandon if he wanted medics. He refused to walk when medics arrived on the scene. Brandon stiffened his body and tried to kick while he was lifted onto the cot. Brandon was combative by trying to pull his left arm away from officers. Brandon again tried to pull his hand away from handcuffs.
No, there was further response to resistance in that report if you wanted to put those in the record.
So there was further response.
There were, but I only hided what I thought was
Well,
necessary.
it's an attempt. I think we got more than enough for an attempt. I was just actually going back to the assault and battery. It says weapons fight, but I think it's, I don't know if it's in the report, but this was not in self-defense, correct?
No.
Okay. Any additional factual basis?
Not for defense.
The board is satisfied with the factual basis. I find your no contest plea to be appropriate under the circumstances of intoxication. I also will enter a guilty plea by way of no contest plea. Let's see here. This matter is set for sentencing March 26th at 9 a.m. You need to go downstairs to meet with probation today so they can get you scheduled for a pre-sentence interview, okay? I'm gonna order that you undergo a substance abuse assessment.
Your Honor, he actually has a letter. He is already currently enrolled in ITRS. That's partly why we got the offer today.
Okay.
So I'll just provide proof of that to the probation department. Is what I'll advise him to do.
I'll note that he can provide proof of enrollment and treatment to replace any substance abuse assessment. Just gonna wait to think about it. They didn't live in the same house, correct?
No.
Do you have any questions at this time? Please do not forget to report to your pre-sentence interview, okay?
I'm gonna take him downstairs now, Your Honor.
Thank you. Any additional matters?
Thank you. And I can just get the police report.
It's in the file. I'm gonna give it Mr. Hornsley because he's gonna probably go with you downstairs.
Okay.
Okay, on the record in the matter of the state of Michigan versus Willie Green, 25-01974, 25-02381, 25, oh, it's the same files, it's just PA 52.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people. Your Honor, Jeffrey Kaplan, P 74943, on behalf of the defendant, who's seated to my right.
We're ready to proceed.
We are, Your Honor. There are a couple preliminary matters. First, the people are prepared to proceed on file 25-1974 with Officer Markham, who, even though is not without the anymore, made sure to come back out here for this. We are not ready to proceed today on the other file, and that is Officer file 25-2381 with Officer Bryant Wilson. For whatever reason, the subpoena never went out from our office to him. And I called him. He is working from home on light duty due to an injury, and because of that, his home is north of St. John's, so he's not able to get here in any type of timely fashion. So I'd ask for a continuance on that one in order to get him here. So beyond that, there were plea negotiation discussions this morning that I'd like to formally put on the record. As charged, the defendant is facing a minimum guideline range between 34 and 134 months in prison. The offer that I received this morning, or discussions that happened this morning, were an offer involving domestic violence in each file with a Killebrew agreement of 12 months concurrent between them. That came from Mr. Kaplan this morning. It appears as something his client had been interested at some point. I said that that's something that we would be willing to do. And then upon further discussion with his client, it's not something Mr. Green appears to want to do anymore. So I want to just make it clear on the record from him that he knows those guidelines, he knows the risk that he's facing, and that he still does not want that.
Thank you, Your Honor. That is an accurate explanation. I actually talked to Jeffrey Billabay and sent him an email about this offer back on October 14th. But of course, he's no longer with the office, and apparently that didn't get forwarded. So I revisited that this morning when I was reviewing my notes. I did talk to my client this morning about that. At this point, he withdraws that offer. Is that accurate? Then you want to continue forward with your exam in this case? Yes, sir. Okay. And I understand the prosecutor intends to run this victimless. And I've explained that to my client. The only other thing I would ask, Your Honor, is for the sequestration order. In this case, as far as the continuance in the other case, Your Honor, this has already been adjourned from, looks like October 9th.
Why?
I'd have to look at my notes, Your Honor.
I know October 9th, good cause to adjourn because the defendant's attorney is not able to appear.
Okay. I don't know. I think I had somebody covering for me that day. I think, and now that you mention that, I think it was Steve Foreman.
It's possible, but it wasn't the prosecutor that caused the adjournment. December 12th, reset, defendant arraigned on bond violations. And that was the reason why, well, part of the reason why we reset it. Why didn't we go forward with the exam on the 12th?
One officer was unavailable. I believe it was due to an injury at that point, but more than that,
The same officer?
No, I think it was actually. Is that you? But the bond violations were a part of that, and then the court had scheduled it for a P53, and then in the course of that, Mr. Green admitted to the bond violations in front of you.
That's in my notes.
So in any event, Your Honor, we would ask for dismissal on the
file they're not prepared to go on, correct? On the file that they're not prepared to move forward on today.
Correct, the 2381 file.
2381.
My client is on parole. He's not getting credit for time served at this point. It has been adjourned at least for a couple of months for the prosecutor's request. We would ask for a dismissal in that case.
People are reissuing this if I dismiss this?
Yes. Given the,
Then I'm not gonna dismiss it. We'll reset it. You can call your witness, and their sequestration is granted.
thank you.
Thank you.
So, this specifically is file 25-1974, and the people will call Nicholas Markle.
Solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes.
You can have a seat. If you can state your first and last name and then spell both of them.
First name Nicholas, Nicholas, last name Markham, MARCUM.
Thank you. Proceed, counsel.
Thank you. Good morning, Mr. Markham.
Good morning.
Now, where are you currently employed?
I guess technically the city of Royal Oak,
And where are you doing in Royal Oak now?
police officer.
Now, where were you employed on June 26th of 2025?
The city of Lansing Police Department,
And what was your role there?
police officer.
Now, how long have you been employed with the Lansing Police Department before you left?
Year and a half.
Year and a half. Now, on that day, did you end up going out to 3600 West Miller Road?
Yes.
Now, is that in Lansing?
Yes.
Is that in Ingham County?
Yes.
And while there, did you end up making contact with a Brittany Pokrafke?
Yes.
And why were you talking to her in very broad terms?
She called police.
As a result of speaking with her, did you determine that an assault had taken place?
Yes.
Can I stop you? Can you spell her name?
Oh, yeah. The last name is Pokraefky. I did my best in pronouncing it.
Okay, yeah. Wow. Okay, thank you.
So as a result of speaking with her, did you determine that an assault had taken place?
Yes.
Did you determine that it was domestic in nature?
Yes.
Did you determine that she was the victim of that assault?
Yes.
And did you determine that it happened pretty recently in time?
Yes.
Now, did you observe injuries on her?
Yes.
And what were those injuries?
She had a bruise on her right arm, her bicep. And that's all I recall. I think she had one. Well, I only recall on her right arm.
Did those seem to line up with what she told you happened in the assault?
Yes.
Your Honor, at this point, I believe there's been sufficient foundation laid to proceed under MCL 768.27C.
You can proceed. Are you placing an objection on the record?
Yeah, the defense just objects to foundation, Your Honor.
The crime foundation to be sufficient, you can proceed.
Thank you. So, who did Brittany say assaulted her?
Willie Green.
And what type of information did she give you about Mr. Green?
She provided me a description of having a tattoo over his eye saying Brittany, which is her name. She gave me that he was on parole, might have violated that parole. And she provided me with a similar birthday, which I was able to run and get a correct birthday, but she gave me a similar birthday.
And by run, what do you mean by that?
So we have a system called Lean, where we can input people's last name, first name, date of birth, and then it'll generate Secretary of State information, warrant information, MDOC information.
So with that, did it produce a result?
It did.
And did it comport with her descriptions of Willie Green that she was giving you?
It did.
Do you see me matching those descriptions here today?
I do.
Could you please point out where he's sitting, maybe something he's wearing, people around him or not?
He's sitting next to the defendant. He's wearing a dark blue jumpsuit. He has a tattoo over his eye that says Brittany.
Record to reflect he's identified the defendant.
Any objection?
No objection, Your Honor.
No.
So what did Brittany tell you happened to her that day?
So she stated, I guess the night prior, she was having a girls' night with Willie's sister. During the day she called Willie was contacting Brittany through Willie's sister saying she's not going to divorce him.
Well, hold on. So divorce, how did Brittany say she knew him?
They were married and they had a child. So Willie was saying that Brittany's not going to divorce her. She then hears Willie banging on her front door, and then Willie entered into the apartment. Then Willie grabs her by the right arm what she said, I quoted really hard, grabs her by the right arm, and then pushes her against the kitchen wall.
Now, you said that he opened the door when it did she say he lived there?
I don't.
Would looking at a copy of your report refresh your memory to that question? If I may approach, Your Honor, it's a
Yes.
plain copy.
Okay.
Now, Officer Markham, I don't want you to read this aloud. What I want you to do is to read this to yourself silently until you feel sufficiently refreshed in memory to this point where you think it's not going to be possible to do so. When you're done, let me know, I'll take it back. All set?
Yep.
Now, did looking at a copy of your report help refresh your recollection of that question?
Yes.
So, did she tell you if they were living together?
She said they did not live together.
So, he's pounding on the door. He opens it, comes in. What did she tell you happened next?
So he grabs her by the right arm, and as she said, really hard. Then he pushes her against the kitchen wall, at which point he wrapped her in almost like a bear hug with both arms, just wrapped her around the body, picks her off the ground. Brittany said at this point, Willie's sister, who was still in the apartment, was yelling at Willie to put her down because at the time she was 3 months pregnant. So Willie put
I'm
Brittany.
sorry, Your Honor, I'm going to object to that. I don't know whose statement that is. That's the sister's statement or the Ms. Bukowski's statement. If so, it's.
I
think he's telling, I could be wrong. It sounds like he's telling us what Brittany told him.
I wasn't clear. That's why I was objecting.
That's why my understanding was.
That's my understanding as well.
'Cause I
but like
didn't know that
said,
he ever spoke to the sister, but
I
you
am-
can clarify.
I'm happy to do a clarifying question for a
Thank you.
clean record down the road. So far, you've said that's all been coming from what Brittany told, right?
Correct.
Did you ever actually talk to the sister?
No.
Okay. So the sister screamed to put her down, and then he puts her down. What did she tell you happened next?
Brittany stated that next Willie was throwing pictures off or pushing windows or pushing pictures off the walls onto the ground in the kitchen. As Willie's doing so, Brittany's picking up the pictures from the ground in the kitchen. Brittany stated Willie was behind her and put her in a chokehold, as she said, and wrapped his arms around her neck.
At some point, did she indicate if this had any impact to her ability to breathe or consciousness?
So she did lose consciousness and she was in fear for her life. Brittany stated Willie was saying during this that he was going to kill her before she went back or before he went back to prison. So she did lose consciousness.
Said she did it?
She did.
Oh, she did lose
She
consciousness.
did.
So he had her in chokehold. She lost consciousness, and he's saying to her, "I'm going to kill you before I go back to prison."
Correct.
What did she tell you happened when she regained consciousness?
Brittany said Willie slapped her in the face. So she said she was going to call police, at which point Willie took her phone from the kitchen table and went upstairs.
One moment. So did she say how she eventually called police if you got her phone?
Yes. She went to the management office. One of the workers in the management office, she used her phone.
Now, what do you mean by management office?
So 3600 West Miller Road is, I believe, part of Pinebrook Manor. So there's a lot of apartment buildings.
Okay,
all
so
with
this
one main office.
This is an apartment building, not a house.
Correct.
So it's the management office for the apartment complex.
Correct.
Got it. And then apart from the injury that you observed, did you end up taking photographs of her?
I did.
Your Honor, I'd like to approach what's been marked as People's Proposed Exhibits 1 and 2. They've been shown to defense, if I may.
Yes.
Now, officer, I showed you People's Proposed Exhibits 1 and 2 before this hearing today, correct?
Correct.
Do these appear, well, no, let me ask it the right way. Do you recognize them?
I do.
How do you recognize them?
I took the photographs.
And where are they photographs of?
The victim's arm and face.
Do these appear to accurately reflect what you observed that day?
Yes.
Your Honor, at this point, I'd seek to admit and publish People's Proposed Exhibits 1 and 2.
Any objection?
No, Your Honor.
1 and 2 are admitted.
If I may.
Yes.
So apart from the injuries that you photographed, did Brittany tell you about any other? Did she describe any pain that she was feeling because of this assault?
Yes.
And what did she say about that?
I believe after it immediately happened, it was.
Your Honor, I want to object. The witness has to know or not know, believing speculative.
I agree.
What do you remember her saying?
She said immediately after it was difficult to swallow. When I was speaking to her, she no longer had that pain. And then I guess I don't recall what she had.
That's okay. Your Honor, I have no further questions for this witness.
I'm sorry, Your Honor.
Take your time.
Good morning, officer. You said that, I'm just going to call her Brittany, the alleged victim in this case. You said that Brittany described her husband for you, correct?
Correct.
And then you ran his name through Lean?
Correct.
Okay, and that would be the law enforcement information.
Correct.
And then you saw a Secretary of State photo in the profile for Willie Green, correct?
Correct.
Okay. And that photograph appeared to be the person that Brittany described, correct?
Through the photograph and other information on the Secretary of State.
Okay.
You said I didn't hear your voice dropped off, the photograph and what?
And other information on the Secretary of State, also the address.
No. Did you show her the photo? I saw.
Don't recall. I don't believe so.
Okay. Did you show her any other information that was on that profile page?
I don't recall.
And you testified that Brittany told you that she and my client were married, or that she and the suspect were married, right? Okay. You were not witness to the assault that you described, correct?
Correct.
The only thing you know about this whole situation is what she told you. Is that accurate?
Correct.
Okay. You testified that you saw some marks on her right bicep in particular, correct?
Correct.
But you didn't see what caused that.
Correct.
That's all I have. Thank you.
None, Your Honor.
Is this be excused?
You may.
Thank you, Officer Martin. Any additional witnesses today?
None, Your Honor.
Let's call it.
Nothing from the defense, Your Honor. Thank you.
Your Honor, I would ask for bind over on all of the charged counts, as I believe there's been sufficient evidence from Officer Markham under MCL 768.27C to establish bind over.
I think issue in one part is the identification. I understand there's a lot of circumstantial evidence that Brittany, Miss Pokrovsky, I forget how it's pronounced, but Brittany described the person she identified as her husband. But the officer never had her look at photo. He said the birth date wasn't accurate. It was similar, the profile that he pulled up, but it wasn't the same. So I don't know, quite frankly, this is not the first time I've heard this, where the officers look at a profile picture, but don't have the victim look at the profile picture and say, is this the guy? I think that's an issue, Your Honor. You know, the officer saw a picture and he's saying, identify my client in court, saying, well, yeah, that's the guy I saw in the picture, but there's a disconnect between what she described and what he saw. And I think that's an issue as far as identification. As far as the telephone interference charge, Your Honor, I heard testimony that, go through my notes. Sometimes I scribble too fast. As soon as I scribble one thing, I forget it, move on to the next. I heard her testify that she went to the management office to make a call, but I don't remember hearing it. Again. If I'm wrong, I apologize. But I don't recall hearing her say anything about him grabbing the phone from her trying to make a 911 call, but she couldn't because he interfered in that. The only part I recall is her going to the office, the management office, to make a call. If I'm accurate, Your Honor, I don't think there's anything that supports that count. With that, we rest on the facts. Now, Your Honor, to dismiss for lack of probable cause.
I'll keep it very brief. For ID, it would definitely help if there was some significant individual identifying characteristic that she gave the officer that everyone can see on the defendant. And, well, he has her name tattooed on his face. I think ID is pretty appropriate. For the interfering with crime report, interfering with electronic communications, the testimony from Officer Markham was, when she finally regained consciousness, she said, I'm calling the police, and he took her phone off the table and went upstairs, which is why she had to go to the management office. So there is evidence for those charges. That's behind it.
Okay, famous date scheduled for preliminary examination on file number ending in 974. As the court has already ruled to adjourn the other matter to allow the officer to be properly subpoenaed. The prosecution bears the exclusive burden of establishing sufficient probable cause that the felonies that you've been charged with, Mr. Green, were committed, and then sufficient probable cause to charge you as the person who allegedly committed these felonies. This is not a trial. They don't have to prove each element beyond a reasonable doubt. It's a very small burden, more than mere suspicion. In this case, we had testimony from one witness that came through MCL 768.27C. That's Officer Nicholas Markham, currently with the Royal Oak Police Department, but on or about the date of June 26, 2025, was an officer at the Lansing Police Department, reported dispatch of a domestic at 3600 West Miller Road, which is in the city of Lansing, Ingham County, making venue in this court appropriate. He made contact with a alleged victim of Brittany Pokrovsky, And she described an assault incident having occurred at that location and stated that the defendant, again, was her husband or ex-husband, that he was presently at that time on parole. She provided a birthday that was, the officer said, was similar to the defendant's in fact birthday, and that the defendant had, Ms. McCracken told the officer that the defendant had her name tattooed on his head. Officers ran a lean inquiry, produced a result, and later the defendant was taken into custody. She being the alleged victim, described an incident that occurred in the home during what would have been a girls' night, to which the defendant's sister was present, and messages were being delivered or communicated through the sister to the alleged victim about not that the victim was not going to divorce the defendant, and that short term after that, there was a bang at the door. The defendant entered the home, grabs the victim by the right arm, pushes her against the kitchen wall, bear hugs her or wraps his arms around her in a form that the officer described as a bear hug, picks her up off the ground while his sister is screaming for him to put the victim back down. The victim at the time is allegedly 3 months pregnant. The defendant allegedly is pushing things off the wall, places his hands around the victim's neck. She does report to the officer a period of losing consciousness, that during this time that the defendant is threatening to kill her while she's in a chokehold, states that he's going to kill her before he goes back to prison. She testified, or I should say reported to the officer who testified that when she regained consciousness, she's reported that she or told the defendant she was going to call the police, to which he took her phone and retreated to another area of the home with the phone, which caused her to leave to go to the management office to call 911. Assault with intent to do great bodily harm, less than murder or by strangulation is count 1. Count 2 is interfering with the crime report, committing a crime to kill, injure, or cause damage. Count 3 is domestic violence. Third offense notice, which would make it a felony. And then there's a count 4, interfering with electronic communications. The elements of assault by strangulation would require the people to establish first the defendant committed a battery upon Ms. Brittany Prokopke. A battery is a forceful, violent, or offensive touching of another person or something closely connected with another person. Second, that the touching must have been intended by the defendant, that is not accidental, and that it must have been against Ms. Prokopke's will. It does not matter whether the touching caused an injury. Third, that the battery was committed by strangulation or suffocation. Strangulation or suffocation means intentionally impeding normal circulation of the blood or breathing by applying pressure on the throat or neck, or by blocking the nose or mouth. It should also be indicated on the record that the people did admit Peoples 1 and 2, which are pictures of the alleged victim, showing a picture of her neck area. I think there was a scratch or bruise above the neck on the lower part of her chin, and it also demonstrates a bruising to her arm. The statements that the officer provided about the incident that occurred does show sufficient probable cause of a violent or offensive touching that was not accidental, and that also included a strangulation, which was the impeding of the airflow, and into which the person who called the police reported losing even some consciousness. The argument of the defense is that we have an issue with identification because the officer did not take the time to confirm with the reporting person, is this the person that you're talking about? I think that's an important step. I don't know why they wouldn't bother to do that if they're already there, if we're relying on what you're telling. And sometimes that could be extremely detrimental in a case. This is not that case for a number of reasons. As again pointed out by the prosecutor, we have a defendant who's got a name on his forehead, Brittany. And the victim or alleged victim's already telling the officer that he has my name on his forehead and that we are married. And although it is concerning that you're married and you don't know your husband's actual birthday, and that your husband would allegedly be so obsessed with you to put your name on his head and you don't even know his birthday. That is a concern. But that's neither here nor there. The birthday was similar, is what the officer is saying. And then another key factor: how many people named Willie Lee Green with a similar birthday are in a forehead tattoo of Brittany are on parole in the state of Michigan at the same time? Do you know? Because you raised your hand. You can give me the answer if you know. Not you? Got it. You're not on parole?
I'm not Willie Green.
You're Willie Green? Okay, how many Willie Greens are on parole with Brittany tattooed across their forehead in the state of Michigan? You know, so I think that the officer, and because he indicated he did confirm the ID and other information, but the other information would include he's on parole. Think that he doesn't have to go and take another step and say, are you sure this is the same one? Because it's not common. There's more than mere suspicion that this is the person who did it. If I take it another step further, I then have this person in my courtroom making phone calls to the protected party, who is a Brittany Prokofsky, and then admits to me that he did it. The court is satisfied that there's sufficient probable cause as to counts 1, 2, 3, and 4. They will be bound over to the circuit court as an habitual offender. Fourth offense notice has also been indicated for further prosecution. We will also address the bond violation in just a moment. Your bind over date is February 18th. That's the date the circuit court's going to receive this file, not a date that you, Mr. Willie Green, no Lee, need to appear in court. Do you understand that? Do you have any questions at this time? I'm assuming that's a no. As it relates to the bond violation, he's already admitted to it. We can have a hearing and I can take judicial notice that he admitted to it.
I don't know that that's necessary.
Want to accept responsibility. That's what I do.
He's on parole until when?
I don't know the exact date. I think he told me 2030 is his bill.
And there's a hold on him, a parole hold?
Yeah. So, I'd have to look at it.
Oh my God.
Yes, ma'am.
Supervision discharge date says July 12th, 2026 is what I have here.
I know his profile. It's not.
Okay, it's not meaningful, obviously, to impose a term of jail time, but I am going to continue the suspension of all of his calls, videos, and visitation.
Thank you, Your Honor.
Okay, and as it relates to the DV third and the assault with a deadly weapon and file number 25-02381 FY, we need to reset that so the officer can be subpoenaed. You said he was on medical or?
Light duty due to the injury,
Oh, okay.
which is why he's not. Sometimes if the subpoena is missed, we can call the officer. They can come over here pretty quick. He's unfortunately working from home because of the light duty, and that's north of St. John's. I have his phone number. I will text the new date to him right now because I'm not a fan of this happening. I'd very much like to avoid this again.
We do March 20th at 9.
March 20th work for you both at 9.
March 29.
March 20th at 9.
That should work for the people, and I just sent that date to the officer. I'll make sure subpoena goes out there as well, but like I said, I am not a fan of delays for this reason.
Your Honor, my client is telling me he's willing to waive his preliminary exam on that case and bind over this one.
Okay, you understand me, you have the right to have a preliminary examination on this file and the right to have witnesses appear. You understand that? Sir?
No, if I waive it, don't stop my 180-day ruling, right? Yeah,
If you waive it, does it stop what?
180-day ruling, so right to speak out.
No. It just means they don't have to have a hearing to establish probable cause.
These are your examination rights. These are what you're giving up by waiving. Any of your questions? If not, so.
Then counsel, you can get you money.
Thank you, Your Honor. I appreciate it. Maybe you can print that for me.
Yeah, that's just what's in there.
Well, it went away when they did a big system update for us with the printer connections for our computers.
No.
So.
I find your waiver on this file to be freely and voluntarily made. This matter will also be bound over for a bind over date of February 18th, okay? They're not paying me.
Sorry, Your Honor.
Bind over date February 18th. That's the date the circuit court's gonna receive the file, not a court date for Mr. Green, okay? And
Thank you.
I know I wrote notes in the other file that his name is not Lee. Where do we get that from? Is there, that's that or something?
I'm not sure. I think we addressed that last.
No, I have it in that file. I'm just trying to make sure it's in this file that his middle name is not Lee. I don't know why it's all over the file.
I have no idea. Yeah, because even it's not Lee in the officer's report, didn't even come up as Lee in the when he ran the lien information based on. So yeah, I have no idea why there's a Lee added to it once it made it to the criminal side.
The bond in that matter will continue at 50,000 cash surety. I believe bond in the other is also 50,000 cash surety. Both will continue, as well as a no contact order. Any additional matters for the record?
Not on behalf of the people.
Not for the defense, Your Honor.
Thank you.
Thank you, Your Honor.
I thought we had a discovery today. Adding something? Oh, okay. No, I didn't, but I think you're here. Or someone's here. Francis?
Good morning.
Good morning. You were here on the discovery matters?
Yes.
No one's appeared.
Either.
Let's see. You can submit show cause on both.
Thank you.
Thank you. Same to you.